accused, Joanne Swartbooi, will find out on Wednesday whether she'll be released on bail or not. But the state has remained resolute that Swartbooi should remain behind bars.
So, Your Worship, as far as the state is concerned, she failed to prove exceptional circumstances and that the applicant has nothing to go home to and is even safer in prison.
Meanwhile, the defense says that there is no need for Swartbooi to stay in custody, especially because the state is working on circumstantial evidence with no body.
The state has mentioned that there is no eyewitness at this point that can conclusively say that the allegations that it is alleged that the applicant burned the deceased, there's no eyewitness. It's all circumstantial evidence. Without repeating what is already placed on the affidavit, Your Worship, we of the view that this applicant has discharged the onus resting upon her and should not be kept in custody as a form of anticipatory punishment. Surely it would not be in the interest of justice that she be kept in custody while the state is still trying to secure a link as to how it links her.
The defense continued to argue that what's been highlighted in court throughout the bail application is hearsay evidence, which should not be admissible in court, but the state has refuted this.
As a general rule, hearsay evidence is inadmissible in criminal proceedings because of its obvious unreliability, which has potential to prejudice either of the parties. In bail applications, however, hearsay evidence is duly admissible. In such proceedings, hearsay evidence is normally presented by a witness from the witness book. The court is not so much concerned with the rules of procedure regarding such evidence, but with the cogency information.
The defense had to give exceptional circumstances why Swartbooi should be released on bail, as she is facing a Schedule 6 offense.
The applicant accused is a first offender, no previous convictions. Even though the children are residing with the mother-in-law, she does intend on applying to the children's court to obtain her children, because now, Your Worship, she has been the primary caregiver of the state children for the past years, or for the whole entire lives of the state minor children.
The state has said there's no evidence that the children are suffering since their mother's arrest.
We have an applicant before court, Your Worship, that is bringing an application. There are no ordinary circumstances. She's a mother of 3 children. Those 3 children are in the care of the paternal granny. There is no indication that these 3 children are suffering. There is no indication that maybe they were not able to go to school because their mother is in prison. No one could apply for them. There is no such. There's no indication that they sleep on empty stomachs or she's abusing them in any fashion. So in the absence of the grandmother, even though this court, Your Worship, is not a children's court, in the absence of her affidavit omitting such information, the assumption will be those children are well taken care of.
With both sides having delivered their closing arguments, Swartbooi will know by tomorrow whether her long-winded bail application process will reach a conclusion. For Newzroom Afrika on Channel 405, I am Tshegohaco Moagi at the Palm Ridge Magistrates Court.